So here's the scoop. You have a trust. You've created some accounts for your trust, but what does not go into that trust and why? I'll share that with you in just a second. But first, I'd like you to think about a friend going through a challenging struggle that creeped into their lives, but they were better prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, outside of some advanced planning tools where you would put, say, an insurance policy within an irrevocable trust, when we're talking about a revocable living trust, we typically do not handle life insurance by changing the ownership of it. Rather, you change the beneficiary designation. Now, this is whether or not you are a single or a married person, you can name your revocable living trust as the primary beneficiary of your insurance so that at your passing, it flows to that trust and all of your wishes under that trust are utilized for that life insurance policy. Now, the second type of asset that does not typically change ownership is your retirement account, especially while you're still working. Your employer is not going to let you change your 401k to your trust as opposed to you as an individual. Now, here again, we use the beneficiary designation rather than the title of the account. However, if you are married, we would always guide you to first designate your spouse. And in fact, there are certain types of policies where you cannot avoid naming your spouse unless perhaps they waived their right to that benefit. Those are a little bit determined by federal and or state law and the type of retirement account that you do have. Outside of that, your spouse also does have the most flexibility when it comes to inheriting the IRA. In fact, they can kind of roll it to themselves and their own type of account. I called it an IRA. It's really any kind of retirement because it can always be rolled to an IRA for your spouse. And then when it's their own, they can take it out over an extended period of time determined by their life expectancy, and that way minimize their tax consequence. Of course, they also have the option of taking it out, sooner, and they have that choice. Typically, if you are married again and your spouse is that first beneficiary, your trust then becomes the contingent or secondary beneficiary. Okay. The third asset that I would say is the most common where we don't title it into the trust is an automobile. Simply put, dealing with the DMV is not fun, and we do change our cars regularly enough that implementing this each time or even trying to purchase a car in the name of a trust at a dealership would be extra difficult. So how we deal with this on most occasions is via the sort of probate surrogates court procedures in your given state. Oftentimes, or at least my knowledge is, certain states will have an allowance for at least one vehicle under a certain value to be transferred to close family members. However, it can be useful, especially as you're aging, to maybe have a secondary person as owner on that title. Or, of course, if you stop driving, to make sure you transfer it or sell it at that point. And just have that accessible so that the family can make that transfer without too much headache. There is one extra hiccup tool, but I keep that for my clients. Anyhow, we suggest that you think about these things as you're creating your trust, and you want to make sure everything is funded properly. We hope you've learned something new here today and that you choose to share. And as always, please take care.